The time, tell me, okay, when you start.
I started the streaming.
Good evening. Welcome. I am Rudolph D'Souza, your host today on today's webinar by MyNation Hope Foundation. Thank you for being with us today. We appreciate joining us on every Sunday on different topics and Men Ki Baat. We started Men Ki Baat to highlight men's issues on various matrimonial disputes because there is no law to defend us against false cases and various domestic atrocities. Not only domestic, it's from police and our system also. Today we are introducing our one of our member from Warangal is Mr. Pramod Kumar. Welcome Pramod Kumar to Men Ki Baat.
Thank you, sir. Thank
We'll
you.
discuss we'll discuss his case, how he was harassed by our system, and how he is facing various difficulties in his life. Mr. Pramod, please introduce yourself.
Sir. Good evening to all of you. First of all, giving this opportunity, thank to my Hope Foundation, MyNation Hope Foundation. So myself, Pramod Kumar. I am from Warangal.
Oh, thank
So
you.
coming to the, hmm,
Okay. Uh, who filed a case on you and which case?
so the case 498, my wife filed on me, sir.
Okay. Any other family members included in your case?
Yes, sir. My other family, mother, father, sister, and sister's husband, and my big father is there.
Okay. So all were staying together or they are staying separate?
Separate, all sisters separate,
Okay.
and
That
my
means
father's
they
brother separate.
included those who are not staying with you also. They are included
They
because they
included.
she just gave their name and police included, right?
Yes,
Okay. Even
yes, sir.
the your sister married and she is not staying. She is staying far away. Still, it's case on filed on her. Even her on her husband.
Yes, even her husband also she filed.
Okay. So without any proof or evidence, and even they have done nothing against her, she just included
Yes,
everyone, right?
yes. Just they are supporting my parents. That's why they put name.
Okay. Okay. So there was no investigation from police side.
No, no. There is no proper investigation.
Okay. Why she filed a case on all of you?
Because of my actually my wife kicked off my parents from their house, so they are
Okay.
staying in my sister home. So that's why
Okay.
they put 490 case. First I divorce.
Uh,
First I file the divorce
okay. So
because of
this case is
from
filed after a divorce.
after divorce my 490 case is filed.
That means she filed in revenge. Just
Yes,
because
it's
you filed
revenge.
a divorce and for some
Yes,
other
sir.
reason you filed the divorce and you have valid
Yes.
ground to file the divorce, in
Yeah.
revenge, take revenge on you and all your family members, she filed 498.
Yes. Yes, she.
Actually,
Yes, sir.
actually there is no reason ground to file 498, right?
Yeah. There is a no reason because we have don't
Okay.
contact with my wife from since 4 years.
Okay. The 498 filed after 4 years.
498 filed is recently happened in 2019,
No, no.
but my wife
You
is not
filed
contacted
you
after
you filed a divorce. Which year
after
you
one
filed
year,
the divorce?
2017. I filed the divorce.
Okay. Okay. That means
Mm.
after divorce, 1 year after you filed the divorce, she filed the 490.
498.
Okay. What's her allegation? She said demanding dowry and
Ye-
harassing.
Yes, mental harassment, demanding the dowry.
Okay. She
Mm.
claimed anything else like you are coming home drunk, beating her, and something like that. Vague
No, sir.
allegations without any. She filed anything like that.
No, no, sir. Actually, from 8 years in our married life, I stayed only 4 months only
4 months
together.
only you stay together.
Together.
Okay. So after all this, police done any inquiry properly?
No, 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 sir. They didn't done any investigation like that.
Or there was no investigation,
No investigation.
and they just copied the FIR as it is in charge sheet.
As is charge sheet, they filed.
Okay. There was no inquiry, no investigation, nothing. They just copied FIR into charge sheet and finished the case. And
Yes,
they included everyone without
included everyone.
any. Okay.
Yes,
Uh,
sir.
uh, has she claimed anything like she gave dowry
Ye-
or she proved any like taking dowry or anything?
No, no, no. See, we don't have any document, any financially, nothing. There is a no documentation is there.
Okay.
Mm.
What is the status now?
Now the status are due to the COVID, our local district court is not running. So this
Okay.
date's postponing.
Okay. You are getting just dates after dates.
Listen, dates.
Okay. Has she filed any other case like maintenance or anything?
Now 498 and they mention uh, this 3 4 DPC they mention.
No, the DPA, all those comes
DPS sir.
under same
For
sections.
DP. Okay.
Not that one. She claim
Hmm.
any other maintenance or any other relief.
No, no, no. So
Okay.
actually she already our taken home. So whatever
That
the
means
getting the rents. Hmm.
she occupied your home.
Yeah.
Its home is in your name, right?
No, no, no. It is in my parents' home, parents' name.
So parents' home and she occupied and parents are outside.
Yes, sir. Parents are occupied. She occupied when I filed the divorce case. Immediately after, in the 4 months back, she came with some local political leaders with the support of the local police. Approximately
Mhm.
10 people came. They attacked my parents.
Okay.
So these all are in the CC footage we recorded. So some political
Mhm.
leaders also involved in this issues.
Okay.
They beaten my father, mother, head injury happened, so a lot of blood
Mhm.
also came. This
Mhm.
then my father mother went out
Okay.
to stay with my.
Even after that, police has done nothing.
Even after that, nothing happened. After some months, 3 4 months, then I my friends approximately 6 to 7 8 people. They support to my parents to enter the home again. She immediately within the 5 minutes she called somebody. Approximately 20 people came. So they
Okay.
again beaten my father. Second case again FIR happened.
Okay.
So again the
Okay.
head injury happened to my father heavily that time.
Mm.
So
Okay.
then I have simply the police station taking the FIR,
Mhm.
written the FIR, making the charge sheet. That's it.
Mm.
And police is saying that she have the right. She is a daughter-in-law. You have the right.
Mhm.
You can stay together. What will happen? We don't care. If you want to come, if you fight means I'll take the FIR. Uh,
Mhm.
I'll charge the cases.
Okay.
That's simply he's
that
telling the police.
that means it shows police is supporting her and whatever she is doing right, and
Yeah.
your parents own house, they are out of
Yes.
home. This is the
Yeah.
situation in India. Old parents are, even judgments are coming,
Yeah.
daughter can occupy parents relatives house, they can claim their even maintenance is she can claim from maintenance from relatives. All this, um, so much biased judgments are coming. there is no proper justice.
Yeah.
It's even old parents. It's not ancestor property, nothing. It's their hard-earned money, and their end days they have to face all this from daughter-in-law, because there is so much support for daughter-in-law from our system. NCW, WCD, all are supporting only young women. They are not supporting old parent, old mother. Obviously, we told earlier also, they are saying if old mother-in-law write to them, they will say you are not coming under our mandate. That is the default answer from NCW. This is the situation in India. How the men, not only men, or the whole family. In this case, the Mr. Pramod Kumar's sister, she is married years, decade ago, and she's nothing to do with this case. Still, her name is included just because she is sheltering old parents, just supporting old parents. That's why her name is added and her husband name is added. They have nothing to do with this case, and police is supporting. Politicians are coming in support of such women. This is the situation in India. Anyway, what is the progress now?
So actually, we applied for a Senior Citizen Act that also rejected from our RDO. So they didn't
Mhm.
given proper justification order to the our parents. So now we are appealing to the our collector, and
Mhm.
we are putting into a high court writ. We are
See,
already
see,
in process.
without any, see, all these things, no need to do. For
Hmm.
senior citizen, High Court is giving directions, and those directions no one is following. They say it should be completed. Whatever senior citizens are asking should be finished in 3 months, 90 days. But here they are just disposing without any remedy, without any giving solutions. They just dropping such any prayers, and there is no value for senior citizen, old or whoever. There is no value, and in India this is the total, I can say, legal terrorism, in broad daylight. Openly they are doing, and politician and police are supporting them. You have Mr. Pramod, you have this is last question. You have any message to our system, such bias system, one-sided laws, and our politician and police? You have any message?
Yes, sir. Actually, the system should be changed, sir, because just because of a female, so this there is a female young lady they're supporting wherever go, wherever. How many we went, all the officer, DCP, ACP, there is a no justice happening. So we want to change the system. So that is
Okay.
the way we want to fight more.
Yes, I will give one more option. You can tell this in Telugu, because those who are watching, those who are familiar with the Telugu, you can give that
Mm.
message in Telugu. Please give
Okay,
this message in Telugu.
okay, sir. Can I speak in Telugu? No?
Yes,
Yeah.
this
Yes.
message in Telugu, against the system, what you are thinking, what you want, what changes you want in system.
ఆ, నేను చెప్పాలనుకుంటే సిస్టమ్ని చేంజ్ చేయాలంటే గట్టిగా ఇది ఏంటంటే మనం ప్రొటెస్ట్ చేస్తే కానీ ఇప్పుడు ఇట్లాంటి నాలాంటి ప్రాబ్లమ్స్ చాలా మందికి ఉంది. సో అందరు కలిసి ఒక్కసారి మనం గట్టిగా ప్రొటెస్ట్ చేస్తేనే ఇది ప్రజల్లోకి వెళ్తుంది. సో ఇట్లాంటి నాలాంటి వాళ్ళు చాలా మంది ఉన్నారు. సో అందరూ ఏకమై ఒక్కసారి ఎక్కడైనా ప్రతి ఇష్యూ కాడ మనం ప్రొటెస్ట్ చేస్తేనే ఇది ముందుకెళ్తుంది నా అభిప్రాయం. ఇప్పుడు ఎట్లా నేను గ్రౌండ్ వర్క్ చేస్తే ఎక్కడ పోయినా మొత్తం ఇక్కడ కరప్షన్ జరుగుతుంది. నాకు ఎక్కడ పోయినా కరప్షన్, ఈవెన్ సీజన్. సో సింపుల్ గా డబ్బులు ఇచ్చి కొన్నారు ఈజీగా. అక్కడ మాకు అర్థమైంది ప్రతి ఆర్డర్ లో ఎక్కడ మాకు రెమెడీ జరగట్లేదు. ఎంత అన్యాయం అంటే వాళ్ళు మా పేరెంట్స్ కళ్ళలు కన్ని కట్టుకొని ఇల్లుని, నేను మ్యారేజ్ చేసుకొని ఒక 4 months కూడా ఆమెతో కాపురం చేయలేదు. బై ఏంటంటే గాడ్ గ్రేస్ గా ఒక పాప పుట్టింది. దానివల్ల ఏంటంటే ఇంకా ఎక్కువ మాకు చాలా నష్టం జరుగుతుంది అనమాట. సో వాళ్ళు ఇప్పుడు 2 years నుంచి మా పేరెంట్స్ ఉన్నారు. సో ఇలాంటి కేసెస్ చాలా ఉన్నాయి. అందరు కలిసి యూనిటీగా పోరాడితే ఈ సొసైటీని చేంజ్ చేయొచ్చని నా ఒక అభిప్రాయం.
Thank you, Pramod, for your wonderful message. There should everyone should come forward. Those who are facing such situation and highlight this issue in media. Media will not cover because those are all medias and
Again,
government's the system's pocket. Okay,
yeah,
anyway, that's why we are presenting in our Mann Ki Baat. Uh, anything you want to say? Anything, Pramod?
that's it, sir. This
Okay,
is my.
thank you for your time and
Uh,
uh, sorry for your situation. Hope everything will be okay and
okay,
your parents, old parents, will get justice.
okay, sir.
I hope so.
I,
If anyone is listening, the government officials, those who can do something in such situation, please do something. uh, you are doing nothing is the same as you are doing those who are doing this legal terrorism. Thank you, Pramod.
thank you,
Hereafter, yeah,
thank you, sir.
we
Thank
will
you very much,
continue.
giving a wonderful opportunity to My Nation Hope Foundation, sir.
Thank you. Hereafter, we will continue with our second session. Dr. Vikas Singh will continue. Please, Dr. Vikas Singh, please continue.
Thank you, Rudy sir. Thank you, Murthy. So today we have two webinars. The first webinar will be given by Mr. Murthy, and the second webinar will be given by Dr. Sarvapalli Pras sir. So first webinar will be given by Mr. Murthy, and it will be about the written statement. So Mr. Murthy is working as a manager in MNC at Hyderabad. So I would like to welcome Mr. Murthy to start his presentation. Thank you.
Yeah. Good evening, all. Myself, Ramanamurthy. Uh, my native place is Eluru. And I'm starting this TEP PPT. Okay. Uh, in case that Women's Party claims to have given huge amount in dowry, and if they don't have income to support such amount of dowry, then you can file a tax evasion petition, followed by RTA and TEP to Income Tax Department against fill and dowry givers. The basic idea is to find out how they were able to give so much dowry if they do not have income. In case it comes out from RTA that they did not have so much income, then their case will weaken considerably. If they still insist that they gave that much dowry, then they will have to explain to IT department why they did not disclose that income in those and previous years. The basic idea is actually the source of income, how they are getting and where they are getting. If they are not getting the source of income, how they have given to us. That is the main basic funda here. IT rules are very clear that if someone hides income to avoid income tax, they have to pay back income tax along with the interest for all the years, and also penalty for evasion of income tax. This is the main basic thing. What is meant by TEP? Tax evasion petition. A complaint letter to income tax department with proof to investigate the revenue loss to government exchequer because of such evasion. Second, why TEP? Mostly wife always gives the list of Sridhana 3 to 4 times from the actual list of Sridhana, huge amount of dairy. Okay, if they are giving only 1 lakh and they will claim 10 lakh, 20 lakh like that. So we have the legal tool for this. We should complain in the income tax department for verifying that they have declared that much income or not. If they have not declared that much income, then require the tax with some penalty. But very few people go to income tax department to ask for everything their income. Okay, when to file TEP? If your wife do the false allegation in DV or 498 FAR and about huge amount of money spent in marriage and Sridhan or dowry exchange of money in our marriage. If your father-in-law has a disproportionate assets with respect to his income, TEP is possible. You have to show undisclosed income, uncounted flow of cash, expenditure extra to file TEP. If the value of the furniture, gold, cash, whatever it may be, was not proportionate to his income at the time of expenditure, you can file a TEP. What are the tasks before filing the TEP? Get the certified copy of the complaint. Get the PAN number if you know. Prepare the proper application. Get the address of income tax department in your area. Those are the criteria enough to file the TEP. What the documents are required to file the TEP? TEP application format, which is available in our MyNation website. DV case or 125 case affidavit of FIR of 498 or any authentic document as per Evidence Act, where your wife told that they spent huge amount in marriage and dowry sridhar. What are the grounds for filing TEP? If you have a FIR copy or DV copy, bills of marriage expense claimed by opposite party, wherein they have mentioned huge amount, bills of marriage expenses claimed by opposite party. If you have the detail wherein they have mentioned larger amount, they are the this is a mainly beyond their capacity to spend. Better to have more and more information like their bank accounts, property also required to file the TEP as evidences. Okay. Suppose your in-law don't have the PAN number. If you don't have the in-laws PAN number, no need to PAN number. Just TP, just give the full name and address details. Those are the enough criteria for to file the TEP. How much time it is take to resolve the query under TEP? Actually, when you are having a proper follow-up with uh, required RTAs and time-to-time RTAs, it will not take more than 1.5 years. It will take maximum 1 year only. But we have to push from a lot of hard work we have to do. We have to push from our side. That is the main criteria for resolve immediately. What are the advantages of TEP? What are the advantages of TEP? For sure, this will go against the 498 or DV family, as it will expose their family allegations. You can sue the 498 family royally with this legal cruelty too. This can be handled without legal aid. No lawyer is required. Fire numerous RTS based on opponent's profile and fast track the TEP investigation. This is a case to case different. We have to file the RTS case to case cases. Okay. You can call the investigation officer with the investigation report using witness summons to in our cost trace. Once TEP is succeeded, we can call the investigation officer. Then all the false dowry will be nullified and their case is weak. You have upper hand. That is what intention of filing TEP. What are the okay, it will not work less amount is claimed as a dowry, and time delays more because of in the terms of RTS, and you people know how the government departments works and information commissions works, you know. Government machinery may not work with the expected efficiency. Very indirect method of attacking the opponents. Where should I make a complaint? How hello, how
Continue.
yeah, how TEP strategy work? First of all, we ask for detailed investigation report of the proven TEP. Once our TEP approved, we can ask the detailed investigation report. Submit the same to in the 498 code, questioning that with IT department also not able to find the source of income to pay such a dowry. The case definitely is false, as it is being investigated by a party having no interest. And that is the IT department, and that too a government department. To submit to 498 court that the family is itself dishonest by nature and hence has filed this 498 for encasing money using a law as an extraction tool. This we can use as a extraction tool. Okay, format of TEP application. There is available in MyNation documents. We can download and easy. We can use it as to shoot the TEP application to concerned departments. Okay, what will happen to? Okay, after we succeed the 498, what will happen to 498 family if you are able to successful file the TEP? That's all. Yeah, they need to pay the tax of undisclosed income. That is the one side. Okay, they need to disclose the source of income from unaccounted amount. Okay, plus penalty, which cannot be less than 100% of the evaded amount and not more than 300% of the evaded amount. Okay, one side, once we succeeded the TEP file, which is filed by TEP, they have to pay the penalty for that. Okay, you will get 10% price, that is price amount that is for our benefit. Okay, following precautions should be taken care before filing the RTA and TEP. Okay, your RTA application is proper and short. Simply what you are going to tell, you have to mention in the TEP. No need to big paras, not required. Only simply what you are going to tell. Okay, you should have a provided grounds for disclosure of the said information by stating that the truth and justice are the superior most public interest. That should be towards the public interest. You have to show in our application, TEP application, that should be in a public interest, not personal interest. Okay, subjects on the denial of information can hamper your liberty and constitutional right under Article 21 regarding right to live with dignity. Okay, you should file the multiple RTAs with short question. Okay, while asking information and RTA Act, care should be taken as there is no need to ask income tax return. Okay, if it is income tax return, that will come in the personal interest.
Mr. Murthy, Mr. Murthy. Okay, Mr. Ramesh, we have questions from YouTube.
Yeah, we have a few questions because we can take it now. I think Parasar can also answer them. Related to TEP, I think one of our colleague has actually filed it through email and he's asking, can I actually follow it up with RTI now? Like while filing an RTI, what can he mention? He just mention that he has sent an email, or should he really get some ID reference for that?
See, he can ask about the he can file an RTA asking about, so he can ask few questions. I would say prepare a detailed questionnaire, like first to start with whether they have received an email or not, and then let's checkmate them whether you have received the email or not, when did you receive the email, what is the action taken on the email, etc., etc., etc. You can start with that with that single question.
Okay. So they can actually file an RTI mentioning that they have sent an email on so-and-so date to so-and-so email IDs, and he can ask for confirmation whether the email has been received and turned into a complaint.
Exactly.
Okay. And we have few more questions. They are actually not related to TEP, but we can actually take it now.
Yes, we can.
One of our friend, John, says that his sister has been issued an NBW for not attending the court case in 498 for 2 dates. How can it be recalled? And is that necessary to take bail for all family members? Like there are 4 alleged accused in this case, so is it necessary to take bail for all 4 members?
First of all, was she served a 41A notice or not? if she was served a 41A notice, she can simply file a recall petition under 70 clause 2 of CRPC. It's a very, very half-page application. I would say one-page application that will be filed in the court, giving reasons why she was not able to attend in those 2 dates. And then it should be recalled. And then the non-bailable warrant should be recalled. That's it. And
Okay.
I don't see a reason to take bail once a charge sheet is filed. They can as well submit sureties and say that they will comply with whatever conditions the court gives, and then ends the
rest
matter.
of the trial process. Yeah.
Yes, number one. Number two, I would like to bring to the notice of everybody facing these cases that there is something called Rule 37 of Criminal Rules of Practice. Very, very, very few advocates suggest that, but that is a simple way to handle these things. Rule 37 of Criminal Rules of Practice talks about one person representing others in the whole of the trial, except when the court insists on others attending to the proceedings. Let me repeat, it is Rule 37 of Criminal Rules of Practice. That's it.
Sure, Parasa. Yeah. We have another question from Santosh Kumar. He seems to have actually received a 498 complaint quite recently. I'm going to be a sufferer of 498 and atrocity in the PS in Andhra Pradesh. Is there any way to stop this false FIR? It seems like, yeah, he got married like 2 years back and now they are blessed with a son, and wife is actually creating a lot of issues. So he's not actually at his own liberty in many of the scenarios. And I think, yeah, this has actually created a issue in their marriage, in marital relationship, and he has actually sent a notice to her to join back, but instead of joining back or replying on the notice, it seems like she is actually trying to file a complaint at the police station, and the PS is actually calling him. He's
See, there
trying
are
to ask for whether he can stop an FIR from happening.
See, he can definitely try mediation in the police station, but I would suggest few things. I would like to ask him, like, instead of, see, he can take it as a suggestion, he can take it as an advice. It depends on few things. One is, what is his fighting ability to fight. So my
Just a
suggestion
minute,
is, if an
Parasar.
FIR yes, Vikram, go ahead.
Yeah, we can take these kind of questions in our group. He has been verified and added to the group right now.
Okay.
Okay.
Yeah, Vikrant, I think it's better we take
think
now.
the speaker
Yeah.
has an issue
And
with
we
his
need to
presentation.
we need to
Yes.
stick to the motive of this presentation, else we'll be longing back.
Okay. Or let me do one thing. Let me finish this question, and then see the issue, and then see if the speaker comes back. If not, I will start my presentation.
Okay, fine.
Right. Let me finish.
Okay, I think the Prasar is dropped out.
If he is willing.
Okay, came back.
I'm sorry. Just give me a minute. Right. Yeah, I'm back. See, the thing is, it depends on his fighting ability. If an FIR is filed, right? If let him figure out what the opposite party wants first of all, and then he can take a call whether to fight or compromise with her, depending on his fighting capabilities. And for that, and for the rest of the information, we need more details. But there is one more thing that I would recommend. Next time if he gets a call from police station, ask them to send him a 41A CRPC 41A notice as per the judgment of the Apex Court in Arnesh Kumar versus State of Bihar. Let him take the name of Arnesh Kumar versus State of Bihar and CRPC 41A. He has to use these two words. That's it.
Sure, Parasar. So, yeah, we can actually further carry on to Yeah, our friend Santosh, it is like, yeah, he can actually try to resolve it as much as possible even before filing an FIR. But even if an FIR is filed, there is nothing to lose. We can actually legally fight it back.
Okay, so I think we'll start our next session. So our next session will be presented by Dr. Sarvali Parasar. He is a dentist and legal consultant, currently pursuing his final year LLB. He has a special interest in matrimonial laws. So he is going to present on written statement. So I would like to welcome Mr. Sarvapalli Prasad to start his presentation. Thank you.
Thank you, Dr. Vikas. Just give me a minute. I am okay. Let me share this thing. I think I have a problem. Chalo, there you go. Am I visible enough? Is the PPT visible?
Yes.
Thank you. Right. First of all, I would like to thank the NGO, MyNation Hope Foundation, for giving me this. I believe this is my fourth opportunity to talk, to do a presentation and share whatever little knowledge that I have. Right.
Prasad, can you, yes, can you hide the another window is there?
Can you come again?
Yes, just hide it. Thank you.
Right. So the thing is, what to do now? For today, my topic is written statement. In local lingo, it is called counter or objections, written objections. Now, in matrimonial, I'll restrict to matrimonial matters as much as I can. Of course, I'll take reference to other. I'll take reference to other laws also, but then I'll restrict most of my presentation to matrimonial matters. Let's say the opposite party files a petition for divorce, and you want to tell your part of the story. You want to object to divorce, or you want to tell your side of the story. What do? You find something called a written statement as explaining your objections to the divorce, to the grounds of cruelty or desertion or whatever. The same way, wife files a petition under CRPC 125 seeking maintenance. Right? What do? You again file a written statement. Same with the domestic violence case. The moment a petition under Section 12 of Domestic Violence Act is filed, you file your written statement stating your objections, showing to the court why there is no domestic violence as such. Right. Let me tell you again, there is a disclaimer. The contents on this site, including free advice, news, etc., is provided by users for your personal information only, and is not intended for trading purposes or carrying out legal proceedings. Right? This is just interest. This is just to inform you. But all said and done, if you are using this knowledge, I would recommend you to use if you're fighting the case as a party in person, you have to use your discretion, right? Before you apply whatever is being told here. If you have an advocate to fight to represent you, I would say check with your advocate. Check with your advocate to figure out what to do, right? Let me tell you, MyNation Hope Foundation does not claim any copyright on these articles. You are free to use these things, but provided you use your personal discretion. Now, what is a written statement? A written statement is the pleading of the defendant, wherein he deals with very material fact alleged by every material fact. I'm sorry for that. With every material fact alleged by the plaintiff in his plaint, and also states any new facts in his favor, or takes legal objections against the claim of plaintiff. Number one, see, in suits it is called plaint, whereas in divorce proceedings, CRPC 125 and Domestic Violence Act, it is called a petition. Petitioner and respondent plaintiff and defendant, right? Who may file a written statement? A written statement may be filed by the defendant or by his duly constituted agent. See, there may come a situation where, let's say, for example, the husband is not in India. He can always give a power of attorney to one of his relatives who will sign on his behalf. Right, a written statement may be filed by the defendant or by his duly constituted agent. Where there are several defendants and a common written statement is filed by them, it must be signed by all of them. And the funniest part is a written statement filed by one defendant does not bind other defendants. Relevant case law, Jugeshwar Tiwari versus Shio Pujan Tiwari. Particulars. What should the written Unfortunately, that's not the way to write that's not the way to draft a written statement.
Rasaji, we lost you a few minutes back. So you start with the particulars. No, the particulars.
You're not audible, because Dr. Vikas.
Just start beginning.
Yeah, you can restart to the point where you mentioned the judgment.
Jugeshwar Tiwari versus
plaintiff.
No, not this one. Yeah. So, yeah, continue. Thank you.
Particulars. A written
Rasaji, we again lost you.
of pleadings apply to a written statement also. Your wife has filed a case for divorce and you are drafting a written statement objecting to it.
Rasaji, start
Yes.
from point one. We lost you again.
Your voice is not audible.
Can you start with the
Yeah, we lost you once again on the same point.
Ye wala, Jugeshwar Tiwari wala.
Yeah, no, that's,
Yeah.
Go ahead. A written statement filed by one defendant does not bind other defendants. Relevant case law, Jugeshwar Tiwari versus Shio Pujan Tiwari. Right?
Yes.
Next, particulars. A written statement should be drafted carefully and artistically. Just give me a minute. I have to switch off my WhatsApp. Just give me a minute. Yes, there you go. Right. A written statement should be drafted carefully and artistically. Is it visible now? Is it properly visible?
Yes. And you are audible too.
All the general rules of pleadings apply to a written statement also. Before drafting a written statement, read the plaint carefully. See, it can be the plaint, it can be a petition also. Like a plaintiff, a defendant can take several defenses, either simply or in the alternative. They may be inconsistent provided they are maintainable at law and are not embarrassing. Right? General rules of pleading. Those who have interest in law. See, these general rules of pleading are covered under Order 6 of CPC. But this is the gist of Order 6 of Civil Procedure Code. Pleadings should state facts but not law. Facts stated should be material facts. Pleadings should not state the evidence. Facts should be stated in a concise form. Now let me take each heading at a go. Facts and not law. The first principle of pleadings is that they should state only facts and not law. It is the duty of the parties to state only facts on which they rely upon for their claims. It is for the court to apply the law to the facts pleaded. Relevant case law. Kedar Lal versus Hari Lal. The law of pleading may be summarized in 4 words. Plead facts, not law. Relevant case law. Gauri Dutt Ganesh Lal firm versus Madhav Prasad. Let me tell you frankly, there are two ways to handle an allegation of dowry in a domestic violence case or a return statement or a maintenance case. There's something called custom or usage. I'm sorry for this, but very few advocates take the defense of custom. But I would say if there is a custom in your religion or caste or family, use it. Because as per section 2 of AP Dowry Prohibition Act, customary payments do not come under the purview of dowry. So coming back to this particular statement. The existence of a custom or usage is a question of fact which must be specifically pleaded. Similarly, intention is also a question of fact and it must be pleaded. A plea about maintainability of the suit raises a question of law and need not be pleaded. Relevant case law, State of Rajasthan versus Rao Raja Kalyan Singh. A mixed question of law and fact, however, should be specifically pleaded. Relevant case law, Ram Prasad versus State of Madhya Pradesh. Similarly, a point of law which is required to be substantiated by facts should be pleaded with necessary facts. Relevant case law, HD Vasishta versus Glaxo Laboratories. Any questions, doctor?
We don't have any questions on this written statement. There is one question on TEP. If a TEP can be filed after 15 years of marriage, might be the complaint is actually after 15 years. So at this point of time, they want to file a TEP based upon the details mentioned in the complaint.
I see a very bleak chance, but then there's nothing wrong in trying, right?
Yeah, TEP can be filed, whether it comes successful or not.
It's something that we cannot predict, but the chances are very bleak because it's too old data.
Yeah, they are having only 6 years data.
Oh, okay.
No, it's not like that. They have 6-year data. I will explain. If you file ITR now, they have 10 years date to check your ITR again. So even after on the 9th year, if you found there is some mistake in your RTR 9 years ago, they can again issue a notice file your RTR again after 9 years. So the 10 years window is there. I know, sure.
Okay. And following question is like, can a TEP be filed if at all if wife and her father are not actually even having a PAN card? Without a PAN card, it is pretty clear. Yeah, it is pretty clear that they haven't actually filed any tax without a PAN card. But yeah.
Yeah, the full name and address is enough to file the TEP if we don't have the PAN number.
Yeah, that is also considered as tax evasion. It's actually like
that's a better evidence of tax evasion.
Yeah, better evidence for that.
Yeah, full name.
And another question. So their full name and address should be sufficient enough to file a complaint on them that they have evaded tax.
Correct. Enough.
This is like not relevant to written, but does in 498 case, is there a provision to provide written statements? If yes, at which stage? In my case, only charge sheet is filed as of now. Date is after 3 months.
No. In criminal cases, you don't file a written statement.
Yeah, thanks, Professor. That's all for now. So,
material facts. The second principle of pleadings is that they should contain a statement of material facts. In Uddhav Singh versus Madhav Ras India, it was held that all the primary facts which must be proved at the trial by a party to establish the existence of a cause of action or his defense are material facts. In Virendranath versus Satpal Singh, it was held that the phrase material facts are those facts upon which a party relies for his claim or defense. In other words, material facts are facts upon which the plaintiff's cause of action or the defense's defense depends. All material facts must appear in the pleadings, and the necessary particulars must be there so as to enable the opposite party to know the case he is required to meet and to put him on his guard. The rule is not of a mere technicality, and therefore, if a party omits to state material facts, it would mean that the plea has not been raised at all. The court will not allow the party to lead evidence of that fact at the trial, unless the court gives that party leave to amend his pleadings. The reason is that non-mention of material facts amounts to non-pleading, and therefore no cause of action arises in favor of such party. The problem here is when you just see the normal way a written statement is filed is they'll write the cause title and then write the heading and then say they'll copy paste the allegation, say denied, and the allegation and the petitioner is put to strict proof of the same. That is all that is written. I have seen at least some 45-50 written statements. Most of the written statements, the same thing is being written. That is not enough, because when the petitioner files their evidence, and then the petitioner is set up for cross-examination. If you don't write your defense in the written statement, there is a very, very high chance of the court not allowing the defendant or the respondent from putting up those questions in the cross-examination. Because when the petition, in this particular case, after you file the written statement and the petitioner comes up with their evidence in the form of an affidavit, when you have not taken the defense in the written statement, it amounts to non-pleading, and hence the court may not allow you to put questions which are not there in the written statement. Facts and not evidence. Pleading should contain a statement of material facts on which the party relies, but not the evidence by which those facts are to be proved. Relevant case law, R.M. Seshadri versus G. Vasantapai. Material facts on which plaintiff relies for his claim or the defendant relies for his defense are called facta probanda, and they must be stated in the plain or written statement. The facts or evidence by which the material facts are to be proved are called facta probantia and need not be stated in the pleadings. I mean in the written statement. Concise form. Please don't beat around the bush. Whatever you want to say, shoot it. Keep it as concise as possible. The fourth and the last general principle of pleadings is that pleadings should be drafted with sufficient brevity and precision. A party cannot be allowed to keep his options open until trial and adduce such evidence as seems to be convenient and handy. Relevant case law, Charanlal Sahu versus Gyani Zail Singh. Every pleading should be divided into paragraphs and subparagraphs. Each allegation should be contained in a separate paragraph. Dates, totals, and numbers must be contained in figures as well as in words. These are the general rules of pleadings and the general rules of defense. Now we are coming to special rules of defense. Any questions, any need to repeat, any explanation required? Am I there?
Yes, you are there. Please carry on. Carry forward.
So no questions, right?
No questions as of now.
Yeah, there are no questions.
Okay, right. Special rules of defense. New facts such as the suit is not maintainable or the transaction is void or voidable in law, and all such grounds of defense, as if not raised, would take the plaintiff by surprise or would raise issues of fact not arising out of the plaintiff, such as fraud, limitation, release, payment, performance of facts showing illegality must be raised. Relevant case law, Kalyanpur Sugar Mills Limited versus State of Bihar. Denial must be specific. If you have to deny it specifically. Don't. Okay. Denial must be specific. It is not sufficient for a defendant in his written statement to generally deny the grounds alleged by the plaintiff, but he must deal specifically with each allegation of fact which he does not admit. Relevant case law: Standard Chartered Bank versus Andhra Bank Financial Services. Every allegation in the plaint, if not denied, because every allegation of fact in the plaint, if not denied specifically or by necessary implication, or stated to be not admitted in the pleadings of the defendant, shall be taken to be admitted. Every allegation of fact in the plaint, if not denied specifically or by necessary implication, or stated to be not admitted in the pleadings of the defendant, shall be taken to be admitted. So if you don't deny an allegation in your written statement, court will consider it to be admitted. So make sure when you are writing a written statement, you have to deny anything. Deny each and every allegation. Denial should not be vague or evasive. Where a defendant wants to deny any allegation of fact in the plaint, he must do so clearly, specifically, and explicitly. Not evasively and generally. Every allegation of fact in the plaint, if not denied specifically or by necessary implication, or stated to be not admitted in the pleadings of the defendant, shall be taken to be admitted. Shall be taken to be admitted. The court may, however, require proof of any such fact other than by admission. There is another case law here. Where the defendant has not filed a written statement, court may either pronounce a judgment on the basis of facts or may require any such fact to be proved. Relevant case law: BAAT and Co. versus East India Trading Company. Examples: defendant broke into and entered into the house of the plaintiff and carried away all gold, other effects which were therein. The correct statement in the written statement would be: the defendant never broke or entered into the house of the plaintiff and carried away all gold and other effects which were therein. Let's say there is an allegation that the respondent broke into and entered the house of the petitioner and hit her, took away all her gold, etc., etc., etc. In that situation, the correct statement would be: the respondent never ever broke into or entered into the house of the plaintiff, nor assaulted her, nor carried away all the gold. This is very, very important. Compound allegation. When a compound allegation is made, consisting of several different distinct facts, is made in the plaint, and it is intended to deny each of such facts, a single denial of the whole allegation should not be made. The defendant should break up the allegation into several parts and deny each of them separately. If the plaintiff makes general allegations in the plaint, they are answered by equally general denials. No complaint can be made by the plaintiff on the ground that they are not specific. When you make a general allegation, you will get a general reply. Relevant case law: Munshi Das versus Mal Singh. Where the defendant relies upon several distinct grounds of defense, founded upon separate and distinct facts, they should be stated separately and distinctly. Important case laws on written statement. So the gist of written statement can be understood by these three judgments: Modula India versus Kamakshi Singh Dev, Balraj Taneja versus Sunil Madan, Salem Advocates Bar Association versus Union of India. So these are my contact details. You can either tweet or leave me a message. So my next topic is interrogatories. Interrogatories are something that will be filed after a written statement, when you need some more information from the petitioner. It is one of the most rarely used weapons in civil procedures. Yeah, that's it.
Yeah, Parasa, we have only one question that's related to the TEP. They're actually asking like whether there is any limit on the amount, if at all, if it's like less than 5 lakhs, less than 8 lakhs of rupees, what they have said as given as dowry, still can they file a TEP?
They can file, but as the amount is less, the department may not take it so seriously.
Yeah, it can be considered as it is more of personal interest rather than public interest, so investigation could not actually happen.
Yeah.
Yeah, that's all what I have on YouTube. Probably Vikas or Vikrant can have some questions.
No, I don't have any question. So I think Murthy sir is not joined again. So
He has
we have.
joined. I think he has already left.
So yes, maybe he has some problems. So we have to finish this webinar here. So if we have any question, any other question, we can take it. Otherwise, we will finish this webinar for today.
Yeah, let's ask for any other questions to post it in our legal groups, and yeah, they can actually be responded in that legal group.
Okay, so I will finish this seminar. So thank you everyone for joining. Thank you Prasad sir for very knowledgeable subject on written statement. Rudy sir, thank you Parmod sir, and thank you Vikrant sir and Ramesh sir. So we'll see you next week on the same time. Thank you everyone.
Thank
Thanks
you, Dr.
everyone.
Vikas. Thank
See
you.
you
Thanks,
next
everyone.
time,
Bye.
next Sunday.